broken baker, where crimes are baked in every show. Mysteries rise and truth unfold. And Ready, said it's time to go.
I did hear Aqua on the radio the other day, and I was just, it makes me think of you, Baker.
Yeah, because I'm a Barbie girl in a Barbie world. Life in plastic, it's fantastic. You can brush my hair, undress me anywhere. Imagination, life is your creation. Come on, Barbie, let's go party. Yeah. Come on, Barbie, let's go party. Ooh, whoa, ooh, whoa. I'm a blonde bimbo girl in a fantasy world. Touch me here, touch me there, hanky panky. Come
Oh,
jump
Lord.
in, bimbo friend, let us do it again. Hit the town, fool around, let's go party. You
I
can
know.
touch, you can play. If you
Hey,
say
thank you so much for watching
I'm
the Karen
only
Retrial.
yours, you can touch,
I don't
you
think
can
he's okay,
play.
guys.
That's as much as I remember.
That's
From,
like the whole song. It's a good job.
That's
That is
terrible, man.
great.
That's terrible.
Okay, so which of you decided to try to hit something with a book and then a high heel to see if there were different wound patterns last night?
Well, Jamie, she's the head of HR in Baker Media, and she calls this, "You've been a good boy." Then she'll smack me with a phone book because it doesn't leave marks. "You've been a bad boy." I'm not gonna say anything about what areas you'll step on with her high heels.
Well, good morning. We're just diving
morning.
right in, ain't we?
Yeah.
You got to pay extra for that where I come from.
Yeah. Why are you telling all our secrets? Come on.
Dang.
Well, this is
What's a
how
buzzball?
Baker Media became a global success with tens of viewers.
Because I'm a horrible person.
Yeah, by Jamie stepping on my groinular area.
Oh, it's
Yeah,
food.
I can
Brandon.
make anyone a success, guys. I mean, come on.
Yeah, if you don't mind a little non-erotic tap dancing in the groinular area.
Can that be non-erotic?
Well,
I think we'd have to ask Brennan.
Brandon, the answer is
anything
yes.
not erotic.
Yeah. I'll
That entire
just do
man
that for
is look.
funsies.
Him saying thrust made me never want to have post-marital relations with my husband ever again.
And y'all, she's got 7 kids. She's a big fan.
I know. I kind of have a thing with post-marital sex. But not after him saying thrust. I was just like, ugh. Mr. Mo will be filing a cease and desist with Brennan.
I would.
And watching stuff, thank you for becoming a YouTube member. As you can all tell, today is charging conference, which will be mind-numbingly boring for most of it. That's why Jemima and Marissa have said, you guys work so hard. We will take over and sit here and just watch 78 hours of them discussing what is and what if. While we will go back to bed and cure ourselves for many, many illnesses. We will try and be here in the beginning where there hopefully will be some motions argued. And then Marissa will come in and she will give you a lecture about Deuteronomy, which I don't know what is, but it sounds fun.
That does sound fun.
Deuteronomy sounds like
Deuteronomy?
a bar in, well, Fire Island.
Yeah, or the islands
San
of
Francisco.
Lesbos, because even though it's in the name, it also allows guys there.
Good to know.
Everybody's so sick, y'all.
Yeah.
Poor Baker last night. He said he got like an hour of sleep.
Yeah, I got hit with the jet lag last night, so I slept for an hour, and then I was just awake for 4 hours, and I thought, should I go live and do my thank you for all the stuff people sent me in Tennessee? And I thought, no, Aiden has that juror on. That's kind of interesting. So I watched that, and then I ended up, yeah.
You
How was
never
that?
sleep
I missed
well.
it.
Yeah, I was gonna say I didn't see it either.
Well, it was quite kind of good. It was juror 3 on X, which was the juror who was thrown out on the last day, the alternate, and kind of confirmed a lot of the things we've been talking about, what worked and what didn't work. Chat is so effed today. Show yourself, YouTube. Come out and get your beating in Minecraft.
In Minecraft.
At least you don't have the vid. We might. I don't get tested for the vid because I'm alone. I was thinking about going to Baby Baker this weekend, but I don't feel well. So if it's the vid, it's fine. I don't have any fever. I'm just congested in the nose and I can't sleep. It's kind of like when the doctors had Valhalla in and said, do you know that you are low IQ, OCD, ADHD? And he said, it doesn't change me. I'm still the same weirdo.
That's true.
You don't need a brand on it. Just know that you're weird.
Good morning, Your Honor.
It is what it is, y'all.
For the
Get
record
you.
before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify
that
themselves
lady?
for the record.
She's new. We
Well,
have to get the
Brandon,
guy.
that's exactly the same
morning,
thing
Mr.
that happened to
Kaufman.
me. I had so many. I woke up one morning in Knoxville with we don't have air condition, and the roof vent was just open, and it felt like I was sleeping outside in the winter. So I was cold. Then I went to the toilet and I just started shaking, and I thought, that's not good. I'm getting sick. But hey, that won't stop me from playing around. So the next night, that was when we were in Dollywood, and someone was guilt tripping me into staying up drinking.
That jerk.
Yeah, probably Volstorm or someone. I
Who
can't
that
remember.
was.
Probably. It was probably Wallstorm.
Yeah, Volstorm is kind of an a-hole sometimes. So I went to bed at like 3 a.m, had to get up and get rid of some of the beer. And I shook so much that I couldn't breathe. I was, so the next night when someone else was guilt tripping me into drinking, I said, no, I'm going to bed. It's Volstorm.
Yeah. I didn't guilt trip you the second night. You were like, I'm going to bed. And I could tell you were feeling sick. So I didn't even say nothing. I was like, yeah, that
Well,
makes sense.
you were sitting with a beer and saying, and I said,
I
no.
was gonna. And then I thought it through and I was like, no, let the man go get some sleep. He needs his beauty rest.
What a kind heart.
My knitting group relies on me for trial updates. They don't know Brennan's name, only refer to him as the scrotum. What happens at knit night? I like it, Island. Appreciate you.
I love it.
That is.
Yeah, Brandon, that's the only thing to do. But luckily, we will be here to annoy you a little bit, so you will be entertained while you're shaking. Because as the famous philosopher said, shake it off, shake it off.
Yes.
No.
Or else you're going to have bad blood.
No.
True that,
Oh,
true
you
that.
two, stop it.
Does
Hey.
Hank Brennan go first? We don't have closing today. Today we'll just be arguing.
Yeah.
So
just be arguing over jury instructions and the wording of the charge that they have to read and all the boring fun stuff.
Yeah.
yeah, stay on the ground and wait for the earth to stop moving.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Why do they even list Lally at this point?
Good
He
morning,
was
Mr.
playing with
Leslie.
paper clips.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so
JN.
Ms. Giannetti and Mr. Leslie, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint
Get lucky there. She
Dr.
got lucky.
Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with
She
the
said-
charge conference?
She said okay yesterday, now she
Your
thinks
Honor, I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of close of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
Oh, he's going to find a microphone.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these 3 indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the
I think
defense.
she's still drunk,
She's a
yo.
leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Al.
Lefty had to put 1 foot on the floor Tuesday to sleep after 4 course light. What an embarrassment. Well, course light is an embarrassment. Believing that Lefty could handle that much liquor, I think there's more reason to believe that the earth is round.
Have they said who's doing closing for the defense?
Janetti,
Okay.
they said that in the beginning, but as always, subject to change.
Well, Alan was asking for the extension, so that's why I was thrown off too. No. I feel
Yeah,
like-
but that's what they said in the beginning. But we don't know. Some
Yeah.
people said Miss Little was going to do it, and
Yeah.
I don't know. I don't think her and Alessi are good closers. They're good tech stuff. They're not good close stuff.
Mhm.
You never had
Yeah,
8
it's
beers
either
in
going to
your
be him
life.
or Yannetti.
Hey, neat.
16-ounce cans. Jeez.
Well, Edward, they have to do it. It's a part of it, and she's never going to give it.
They got to do it
No,
for appeal purposes.
But they
Yeah.
have
They
to do
gotta
it,
put it
yeah,
on the
for
record.
appeal purpose.
Put it on the record.
I think they should dismiss it, right? Like, I think it's valid, but
Yeah.
they
Oh.
won't.
Yeah.
Yeah.
After the defense's case and Hanky just, throwing bombs on his own witness. You don't know anything because my guy doesn't know anything. No one can do tests to prove this. I mean, come on.
Remember
He
this.
he didn't get that piece into evidence. That's the ruling she made this morning.
There's
Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello.
I know this is going to be absolute fantasy writing here, almost as fantasy as Plevin's book. But actually, what a swerve it would be for Bev to deny them right now and say, I agree, there has been no evidence provided other than some kind of backing up maneuver that your own expert testify he could not determine John O'Keefe was hit by a car. I dismiss this
That's
case.
what should happen.
Yeah,
That's
but
what should happen.
imagine if she was a real judge and she did that at this point, the amount of cope I could mine from Plevin and people like that.
Oh,
We
yeah.
have to put Plevin on a watch.
Yeah.
He might need
And
to be
Coffee
checked on.
Daffy. Someone would have to do a wellness check on her.
Oh, she won't
Her
care.
and
She'll just move
Wendy
on to the
and-
next grift. She'll
Yeah.
just move on to the next case that's paying her for PR. No big deal.
And
How can you
the-
use a HARFSR card on board DoorDash? I don't know what any of that is.
a health
For your
savings account?
medical-
Not
yeah,
for
your
booze.
Medical insurance. No.
Well, booze
I don't think that's gonna
technically
work.
is good when you're sick because
Good for the
it'll-
soul every day.
Yeah, and it'll lower. Well, in a considerate amount, it'll lower your heart rate and your fever and help you get some rest. I say go for it, Brandon. Does anyone know
Well,
what
your
Exhibit
DoorDashing
KKK was?
medicine.
It was 4
Exhibit
days.
KKK was dismantled in the late 60s. We don't talk about that anymore. KKK was, I believe, the X-rays, but I'm not 100% sure.
So I believe that was Dr. Rentschler's PowerPoint, and she said that that wasn't being allowed into evidence.
No, because there was
of
four
Brennan's-
different,
Exhibits.
3 different KKK, set, AAA, BBBB was all denied. As far as that's what they talked about yesterday. So I think it might. I'm not sure about what it is. I don't know. We'll have to go back and find it. Jamie will do that while she's sitting here with Marissa and Jess listening to Charging Conference later today.
Oh, yeah.
That John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to
Chad's
Ms.
right,
Reed's Lexus
by the way.
was inconsistent.
What?
I think chat's right. I think it was YYYYZZZZ. I think those were the right ones. KKKK was a different thing. Those 4,
Oh,
something
never
about
mind.
Alessi was trying to figure out those 4 because they were marked for identification.
But she
not
hadn't
for
put them in
evidence.
for evidence.
Oh,
And
the
she said
YY.
she had or something.
Yeah, why set A and B was the ones that the 2030 ABC, which she then said they are marked as 2023 ABC. Yeah, that was something weird. So let's agree at Dr. Rentschler's PowerPoint is KKKK.
Agreed. No idea if it's true, but agreed.
I'll
Yeah,
stipulate.
Sure.
not Shizzy's weekend club. That was an extra in this one.
with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless
not?
experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case.
Well, I did say I wasn't going to stream today. Then multiple people started yelling at me, and then I said I'm going to stream the hearings when we get into the what if, and can we change line 237 in the jury instructions. Marissa and Jess will come in here and take over because they really like to sit and dig deep into that. If they don't, you'll have to take it up with HR, which is Jamie's driveway, where you can throw a rock with a note on it between 6:01 and 6:01:01 to complain about it.
Also, me and Jess have a bet on whether or not Marissa can get us demonetized with no evidence being involved.
Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry. I meant Higgins, yes. Yeah, the same Brian Higgins. Who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
Denied.
Obviously.
Excuse me, my instruction and Dr. Judson Welcher is a leader in his field.
Oh, Lally.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine.
You're talking about biased witnesses?
Whoa.
We watched the Blue Man Group on the stand.
Yeah.
Nelly,
Yeah.
I like that you finally gave in and took down most of it. You still have the fluffy fringe. Let it go. Do like Elsa. Let it go. But
let it go. Let it go.
Get hair plugs and let them
Did they really think that they brought that out so like apparent that they were. It's so terrible.
Yeah, the medical examiner for the state of Rhode Island. Yeah,
Yeah.
she's super biased by nature.
Yeah.
Not to mention your witness, who is still in pursuit of his bachelor's degree, wherever it may be in the Great Valley.
And the guy who, well, it totally could be like this. So he's testifying his arm was out. No one said his arm was out like that. Where do you get that from?
I love that. I'm doing a test to show that the pattern lines up, but I didn't say that that's what it is. Like, are you serious? Like, what?
On Thursdays, we do arm, because if you want to be in the back of a target, donging a thick mommy that smells like a fish market, your arms better be effing swole. And I can attest that having a little bit of the Danish flu will help with that, because the fish market will be a little
Can't smell
lower.
it. Can't smell it.
Oh,
Oh, dear Lord.
Take that, Marissa. See if I can get you us demonetized before.
Goodness.
Hey, Reeby. Rip it.
Hey, Reeby.
Hello.
Almost case in any way, shape, or form. A couple of specific examples. When it came to Officer Barrows, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots
That's
from
not what he
that ring
said.
camera video. Essentially, Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. Laposada talking about the drop in body temperature.
Remember all those motions you filed that said that the ARCA guys couldn't talk about what caused the abrasions? Am I living in bizarro world? I know it's not because of your brain power that your hair plugs won't stick, but buddy, your team made it impossible for the ARCA guys to give any kind of explanation to the superficial abrasions. It was your guy who stood up there and said it was lacerations.
It wasn't just
Yeah.
ARCA. They did it to every witness. They made it so each witness couldn't talk about a different subject that the other witness was talking about, so nobody could corroborate. Although they tried. They did. You just blocked it from being entered with your grimy.
but moreover, like
grimy.
ARCA isn't really going to say that either. They're just going to say what they are per what the doctor called them. So that means nothing. It means nothing that the ARCA people said what they said. The
medical
doctor said
examiner
what they
wasn't.
Yeah.
The medical examiner wasn't allowed to say dog.
Yeah, the medical
I totally cut you
examiner.
off there. I apologize.
They kept a lot of that out. Yeah.
All of their experts agreed that he wasn't hit by a car. We want to, go with ticky-tacky things. ARCA tried to say it could have been the taillight. They, in fact, tested extensively to see if the taillight would line up. That wasn't them disagreeing with, the experts that were brought in to say these could be, animal teeth. This was, in fact, saying, hey, the, tail light didn't go full, canine mode and bite him.
Yeah, it didn't turn into ninja stars and just slice up his arm.
Sure, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of.
Could you imagine paying for that haircut?
Claims to have driven by there and not seen the body. This is the same witness who is, I would submit,
Could you
very
imagine
confused
being the
sometimes, and then also
barber?
backed into,
I'd
a
like it
basketball
tight on
hoop,
the
during course of
sides
his
and
plow duties, on
a
that
4 on
particular
the
early morning
top.
as well. And as the court could see from the cruiser camera video,
That'd
drove
be the
by the
easiest
scene
haircut
countless
ever.
times,
I mean, you don't
essentially
got much to work
rubbernecking
with.
it as he's going past doing his duties. Your Honor, what
I think
Commonwealth
they
would
just
submit is that
charged
his
him
case
for like a beard
was
trim. Called
more
it
than
even.
sufficiently strong at the close
Exactly.
of the evidence in this case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to Commonwealth, and request that the defendant's motion be denied.
Get
I
ready.
was not even going to think, and denied.
And viewing it that way, met its burden, so the motion's denied. Okay. All right, so regarding
Well,
the
I don't hope that for anyone. But I just
So we'll
hope that he has his
start
come
with
to Jesus
the
moment.
Defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize. We made the decision last night to withdraw 2 of our requested instructions with shorten things today. I think it's,
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking to give regarding the display of this sweatshirt.
Oh, that's right, I saw it in email. I don't have a hard copy of it.
That's just for lessons.
Your Honor, if it's helpful, Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions? Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right? All right, so model homicide instructions, just as last time, so that takes a lot of time out of today.
Where's Marissa at? Bottomless brunch. I've heard that she's going around Donald docking at brunch right now. So what that means, I don't know. But she sent me a text message saying, "I'm out, MFers. I'm Donald docking this Tuesday."
Donald ducking.
I don't know what it means. I don't know.
Oh, you don't know what it means, I'm sure.
I don't, Jamie. I don't speak jive. That's
Oh my god.
That's terrible.
Well, maybe it's thinking someone has schizophrenia. How long to reasonable doubt? Well, in this courtroom, a long, long way. But hey, Harry, hope you're doing well. I'm considering hiding the bus ball for safety. Well, I think you might need to give it to your wife today if you're sick and get a little whiny. Because some men do that. And I don't, but I'm always almost just about to kick the bucket when I'm sick. So when I complain, it's because I am sick. Most men is just because, oh, man flu. But I've never had the man flu because the man flu is impossible to survive.
It really is. I mean, forget birthing children, women. We've never had the man flu.
Yeah. Oh, thank you, Edward. Oh, Marissa, don't do that in public.
No kink shaming.
Well, I'm just saying, don't do it anywhere near school then.
That's probably good advice.
Yeah, that's a good advice for a lot of things.
That's a list you don't want to be on.
No.
What?
All right, so we will deal with that. I'm going to go through the
Get to the
defense
mics.
instructions are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will
You
give
have to
some
have a
version.
presumption of
I know
innocence to
that
have
there
a
was a lot of
robust
attention
one.
paid and some appellate decisions on the
I think it might have
each
been Jim.
individual indictment. I'll give some further language on that. You've got an instruction to propose on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it. So I will make it crystal clear. Okay. So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Mr. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction? Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden,
We're objecting to Bowden?
And I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry.
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses to the stand. It is said what is evidence or anything of the like. So in the instruction and the arguments are based or predicated in the case law on evidence. Not obviously, as well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only both or third-party culprit instruction, but specifically for even counsel to make that argument during the course of closing. And I understand Bowden is a little bit more loose as far as we're certainly.
So
Are you actually retarded? There's
Is Hank
no
moving
evidence.
his mouth as he's reading?
He's saying there's no evidence provided that could lead to a Bowden defense. The highly biased lead investigator, the
Who's now
absolute
fired.
lack of custody, chain of custody, the lack of any photos that can establish the crime scene, the multiple infractions where they should have stayed away from the CPD because they are related or friends with witnesses in this case. And none of this could be leading to about a Bowden defense, which is they did a shitty investigation defense.
Well,
Remember,
yeah,
they filed a motion that they weren't allowed to bring in an expert to testify that this was a shitty investigation on the grounds that everyone in the audience can establish, in the jury can establish on their own merit what is a bad police investigation. And now they want to say, well, you couldn't bring any witnesses to say it's a Bowden violation, but we were the ones who took away your witnesses. She better give that one. Hey, a wise man once said, you can't predict a hero after diving on a grenade with his helmet in Nam and becoming CEO of UBS and the first director of Homeland Security. I'm making a comeback, baby. Well, welcome back. Brandon got his second win. Sorry.
Also, I'm just so proud that Hank let his, silent partner talk. I think they might have let Lolly talk after the entire internet was joking at him playing with paper clips yesterday.
Yeah.
And or it's just hard for him to sit down and stand up so much because of the yelling he got after yesterday.
And I'm thinking Brennan is sitting there covering his mouth because he heard there's a Danish pox going around, and he's going to save himself for tomorrow. And I've seen a lot of people are doing hey, we're going to do the closing that Jackson should make. We don't do this on this channel because I write the short bus. There might, and this is still unconfirmed, there might have been a secret recording of Brennan doing a pre-closing rehearsal. It might drop before tomorrow. I have some sources. I'm talking to Plevin, Daffy Gaffy, and I'm just saying, look out. Brennan might have dropped a fiery closing argument. So keep an eye on the channel. It's not long.
But mostly peaceful.
But that's what his wife
peaceful,
said.
Everyone.
It's mostly peaceful. It's less fiery than California.
I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to package evidence. Chain of custody was contaminated and corrupted. There was evidence of bias. The investigator failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about in an investigation. So to say that we didn't introduce that evidence when we tried to do it.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know. But
We just
tell
need
me,
that the
are you going to argue
investigation
it?
was crap.
Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And I actually think that's good.
Yeah, I think that's good. It's like we have been saying since the beginning of this retrial, don't focus on the who could have done it, whether it's Jen with the bite marks or Higgins with the, nuclear belly flop and John fell backwards. Let's focus on this investigation was crappy. We have still, yet to this day, don't have the exact location of where John was on the stupid lawn.
And where any evidence was found in connection with his body either. So, yeah, I love that everyone is saying, but the debris field. Yeah, the debris field doesn't prove shit because you don't know where the body was. Oi, mateys, I haven't seen these many lip noodles in a court than before I resealed my deck and applied some big black caulk. Now all is rock hard. That's my Australian accent. I've heard it's
better than your Southern American accent.
Mazel tov, Brandon.
I heard a lady in Walmart who had exactly the same accent as me. Please do not disparage my Southern accent. I'm more Southern than you are, son.
Hey, easy now. You better calm down with that nonsense.
You only have had biscuits and gravy once in your life. Have you ever had
I
grits?
had a Southern waffle as well.
And it was last week.
You never had a Southern waffle.
Baker's gonna come back to America with like a denim vest, singing "Sweet Home Alabama."
Take it. Yeah, I'm just my play-out music will now be "Sweet Home Alabama." Baker is straight out of Mayberry.
Am I the only one that found it bizarre? Right? Like if they wanted to argue that it was Brian Higgins, they wouldn't be allowed to. But since they're not arguing that, they're allowed to blame Brian Higgins.
No, they're not allowed to say Brian Higgins did it, but they're allowed to say the investigation
Look at
was
Brian Higgins, though.
No, but they're allowed to say they knew there was some kind of affair going on, and they didn't ever look into that. That's not saying that's why he killed John. So they're not allowed to point the fingers. They're just allowed to say, well, the police didn't follow up on every lead. They could say they never looked in the basement. Never looked in the house.
Just seems
Yeah,
counterintuitive.
I mean-
You know what I mean?
Valhalla, you have been
Welcome to
overruled
America.
by a true Southerner, Volstorm.
Ain't happening. Ain't happening.
So Ms. Gianetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to, Commonwealth has objections to the DQT instruction. That's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Gianetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right, so, obviously it's not the strongest DQT argument that we would have to not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done, it wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording, so we still think we're entitled to.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded her. Someone who was not familiar with dealing with police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr.
And
Hill?
if I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to the issue of custody and my client being able to deny.
All right, what do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the juror spoke to.
Check mate.
You're out of your damn mind. GG, stop it.
Bless your heart, Valhalla. You lost it.
Oh my God. Oh my God.
No, we allowed Bowden, and they were allowed to argue about Higgins having that affair thing, even though, hey, I've hit on women better than that, and I've been single longer than Jesus was on the planet, which was 33 years, and I'm 27 years old. So they allowed the Bowden defense that it was a bad investigation, and they are allowed to say, example, they didn't look into the affair between Karen Reed and Brian Higgins as an example of a bad investigation, but they're not allowed to say, and because of that affair, Brian Higgins killed John O'Keefe.
Yeah.
Used to be at our parents' house, as they did with a number of different witnesses on that day as well. Over the course of that, they spoke to her while she was seated on the couch in the parents' living room. The parents were present. No one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody.
I would like them to use
Yes,
the
they did seize
microphone.
her cell phone and her vehicle, based on,
Yeah, especially because my ears are clogged.
From the street itself. But I don't think that transforms that conversation or interview in a parent's living room into a custodial interrogation. The bigger issue that I have placement, as far as there's already been within saying requested jury instructions or requested jury practice, and then following the DG and Batista language in defendant's requested jury instructions.
Can they mention red solo cups and snowblower? Yes, that's Bowden. A Bowden defense is just the police never took another look at crucial evidence. The police didn't do a good enough job preserving the evidence. The police didn't do what you would do in a normal investigation to prove something that went on. That's the Bowden defense. So it's all the bad stuff they did in the investigation or didn't do in the investigation. And thank you, Tammy, for gifting a Valhalla Awaits membership. Mo, you said yesterday you have the chats up, so can you see who got it?
That went to Eric Bulldogs, but it's got an O with a little slashy thing through it, so I probably...
That's an Ö.
Bulldogs. Look, I have complete...
Maybe.
Bulldogs.
Let's just call
again,
him.
I apologize for butchering
Eric.
your name.
So the Commonwealth wants to exclude a Bowden because they didn't have a witness, because Bev denied them a witness today, like every other day of the sham trial. Jen, the couch fairy, you are correct, Amundo. Do you think Lally is going to do closing? Lol. If Brennan when he said yesterday, I don't care how much time we get. I think the only thing he's waiting for is just to go up there for an hour and play out of context clips of Karen Reed saying, I hit him, I hit him, I hit him, I hit him, I hit him,
Yeah.
I hit him, I hit him, I hit him, I hit him, I hit
Well,
him.
and I think those of us who are on the state didn't prove its case have to be realistic that Karen doesn't sound the best in those clips. They are very damning. And if you are the type of person who thinks that she's, using her money to try to get out of everything, she's got big hotshot lawyers, those might play well with you. Or if you're just like, hey, she was drunk. I don't care what they proved or didn't prove. She was driving drunk.
Yeah. That's what they're going for. And I have to reiterate, some juries will find her guilty in the manslaughter thing just because she said she was drunk. Hopefully there will be enough that can say, get off that ledge, you're stupid. But we know that's the discussion they had the last time was, well, she was drunk. But the manslaughter part, but she was drinking. But the manslaughter part, she was drunk. He wasn't hit by a car. She was drinking.
Well, and Sebastian, you make a good point as to why she said, did I hit him at the point when she saw the body or John's body. But I think there are still going to be people that I don't think it's going to extend to she was drinking and she was driving that night. So I think that, Dr. Russell did a good explanation for the acute grief reaction, but there might still be people that don't believe Dr. Russell. And, again, think there's a lot of people on on X. I don't do TikTok. That put out that, all of the defense's witnesses were paid advocates.
Yeah. And the problem is they let her talk. Never, ever let your defendant talk, because it will be used against you, taken out of context. And Brennan has won. This is going to be like Eli Manning when he was in the Super Bowl against the New England Patriots. He shook off, I think, 3 attempts to tackle him and just hoofed the ball. And yes, take that, Tom Brady. This is where Brennan is 4th down, 38 on his own 55-yard line. All of this is sport metaphors that Mo is now thinking, but where's the golf ball? He has one shot, and that one shot is people will hate a drunk driver. I personally don't like people drinking and driving, but I would never find someone guilty just because they were drinking and driving. And sadly, jurors are stupid.
Yeah, they don't understand the law.
No, because they will do. I've said it a lot of times with they will take all this evidence and then they'll go in here and say, "Oh, yep, this piece of evidence is all I look at." Yeah, but what about all the other evidence? Yeah, I don't care. And we know that from the first one.
They sure do.
Yeah. Oh,
I highly doubt they'll get all 12 to do a guilty, but I don't know.
Well, that's why I worry about it being hung.
Linz, again, it doesn't matter what the statute says, because the jury will determine if they find her guilty. And you can then argue and say, the law has nothing to do with deliberations. The law has only something to do with these weirdos who is in the room right now. The jury is outside of the law. There's no one who will go in and say, but are you stupid? You need to prove every prong of the charge. No, they just come back and say, I find her guilty. Then she is guilty. Good luck on appeals. You're guilty. It doesn't matter if there's 5 prongs or 35 prongs or 1 prong. If the jury finds you guilty, you're guilty. The law has
Now-
nothing to do in deliberations.
I will say that I think it works well for the defense that this is a younger skewing jury. I think that it really works well for the defense, mostly because as I can tell you, Dr. Welcher's PowerPoints were absolutely cluster headache inducing. And however you want to look at it, the defense's experts were easier to understand. Dr. Welcher just talked about, laying down on a bed and stupid stuff, as far as I'm concerned. So and you also have to figure out who's going to be the biggest loudmouth. Who's going to argue your point? The closing arguments are a time to basically give your arguments to the jurors that believe your side, so they can argue with the other jurors and say, hey, but this didn't match, and this didn't match, and remember this didn't match. And both sides are going to have people on the jury that, align more with that side, unless the entire jury has seen this and then heard Hank ask about a ham sandwich and they're all out.
Yeah. And again, I want a roast beef sandwich.
I know. Now I want Jimmy John's really
all
bad.
these other requests regarding your compromised mental state and all these other things that, while if it were to be given by the court, should be given in the same context of the practice. I don't think it's something that should be
Oh,
highlighted.
Lolly, work on your
Because
hand
there
motions.
is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have this testimony to stand, that initially she said she wanted to be fine with answering questions, but they wanted many details. And then when the questions became more centered on details.
Yeah, I've read all of Sue's updates. Some jurors are very engaged, some are not engaged. But again, what does that mean? This is the normal, I can read minds. What does this mean? Does this mean I am very intently listening, or does it mean I'm so bored my head might fall off if I don't hold it?
Well,
I
and
have
just look
what's called a Scandinavian stone face. I will listen to everything you say, and most of the time I will sit like this.
Well, not to mention, just look at us on the panel. I've been taking, religious notes, but Baker and Valhalla haven't, and they've still been able to, be just as right, if not righter than me on facts. So, there's going to be some people that, like to rely on notes and some people that don't. All of this is soothsaying. I mean,
yeah. It's tea leaves. Try and hate on ham now. I dare you. Well, I don't hate on ham, but I would rather have a roast beef sandwich because something with a little flavor, because I'm a little stuffy, so I can't taste ham. Ham is a little boring.
Can we all agree that Canadian bacon isn't bacon? It is ham.
Yeah. It's just I like Schwarzwälder ham instead of bacon because it's a little less fatty, but it tastes the same. So I use some thinly sliced ham as well. And again, but don't put anything into it. When you read Sue say, well, jurors are doing this, jurors are doing that, it's the same when people are saying, oh, Karen Reed has been scratching her face a lot during the defense part. What does that mean? Nothing. Anyone who will tell you, they can tell you what the jury thinks. They can tell you if a witness is lying just by looking at them is lying to you. I hate to say this because I know body language is a really big seller online, but there's more hard evidence proving clumsy clairvoyance tarot readings are real than anyone who will tell you what the jury thinks or what a witness thinks by just looking at them. Body language is real. You can do it, but it'll take hours of baseline studying a person. You can't just look at someone and say, because they do this. Because again, I have a stone face. You know when I break. It takes a lot for me to break. Valhalla, he laughs a lot. We can be having just as much fun, but I'm just sitting here. And it's not because I don't find it funny. It's just because I don't laugh at stuff. So anyone who will tell you you can read people's minds, through their face by just looking at them for 5 minutes. It's not true. It's BS, but it's a good grift. By the way, tomorrow, body language on a budget. Jamie will run through everyone on the panel, and she will tell us how they think.
Yeah. It's going to be great, guys.
Terrifying.
I'm good at it.
But Smiles and rolling eyes says a lot. Yes, if you know what they normally do, if you know when I get nervous, I do this a lot, then you can tell, oh, he's nervous now. If I'm nervous, I drink a lot. You can tell that. But you don't know that. Just because Jen McCabe looks like a horse that's got beaten in the Kentucky Derby, it doesn't mean she lies. Everything that comes out of her mouth is a lie, and you can tell because it's a lie. But it's not because she looks like a horse.
23andMe for her and Sarah Jessica Parker being related, because
they're both related to Mr. Ed.
You said it. I agreed.
Am I ticklish? No, I'm not ticklish. But will Jamie do it while Donald ducking? Jamie is Donald ducking it 100% right now.
Jamie doesn't even own pants. Why do you think she doesn't leave her house?
Guys.
Hey, I don't own pants.
Well,
I keep trying to do a super chat, but it keeps telling me to edit. I'm not saying anything inappropriate. No clue what I'm doing wrong. Well, Mary Casey, you don't have to send any super chats. If you have something, we might pick it up. But thank you for considering it. Mr. Ed is their grandfather. Exactly.
yeah, with your new Donald adopted it everywhere. No.
Well, so did the ladies, and that's why he has so many love children around the world. It's not only Batman and Robin who had smacks with a lot of women. Mr. Ed, I heard he was quite the player.
At that point, I know that's not a jury, but of course, where she then ended the questioning about the law. So I don't think there's any evidence
It's our prison.
for having a compromised mental state for the course of this interview. And I don't think that it rises to the level of these instructions. So I would ask basically that everything on page 8 prior to the 12 instruction be exercised.
All right. I'll take another look at this and
So
I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that does not apply to the interview at her residence. But we believe that it applies in the humane practice
That
context.
is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the,
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked for it to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence.
Linz, I'm just saying because I've seen a lot of people on Twitter saying, well, the jury is clearly for Karen Reed. We just don't know. I actually think it was kind of the same last time. A lot of people were shaking their heads and nodding their heads. For me, I would be sitting in there.
Oh, yeah. If I were a juror, I mean, look, y'all know my face on here. I will say that when I did jury duty and they made me foreperson for reasons I cannot yet comprehend, the prosecutor must have thought that I was on his side because he kept directing all of his arguments to me. And I had already decided I wasn't going to vote guilty for anything. And I felt bad because he was like really, talking to me like he wasn't making eye contact with anyone else. And I was like, no, this is the dumbest case I've ever heard. Not barring this one.
Like, man, I'm not on your side, bro.
I know, I felt bad. I didn't even stay so he could ask me what he did wrong. I just felt so bad because he thought I was on his side. So I ghosted him.
A duck is to water what a donkey is to Tijuana. Well, yeah, I just don't laugh a lot. That's everyone is saying, why don't you smile? I don't know. I've never done it. It's I'll laugh if I watch a funny movie. I'll laugh at it and stuff. It's not like I am devoid of human emotion. Hate is an emotion.
Danes really are subhuman, you guys. They're born without the facial muscles involved in smiling. They're not the same as us. They're different.
I get Baker to laugh sometimes, but it's always because I'm being a dork.
Yeah.
One of my favorites is when Baker breaks because he's trying to hide it. He's like,
Oh my gosh. When I came in as, oh gosh, was it Earl or I can't remember the guy whose mother-in-law had questionable morals, but on Halloween when I came dressed up as that,
Glenn.
life achievement unlocked. I broke Baker for reals.
And thank you, Mary Casey, for a $10. That's the wrong color. $10 super thanks, whatever they're called, super sticker of a pair saying thank you. Your third super on the live stream. On a live stream. I don't know why it says that, but apparently it's so I can grift you harder saying, oh, you have 3. You can make it 4. Don't do that.
Evidence you're withdrawing, direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
Can you pause, Baker?
Sure.
Language in there I would object to.
Okay.
That's when the police officer or someone else works for a law enforcement.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
I'll do police officer because they're police testimony. I'm not going to go beyond that.
Moniji always a little behind. Why is Colin off the table? He's been off the table the entire trial. Now the third-party culprit directly is also off the table. And it's not that he doesn't deserve special privileges or do deserve special privileges. It's just nothing has been put in that could point to him as a potential third-party culprit.
I'm sad as there's going to be no more rage drinking for me now this case is about over, lol. Well, we'll find something else to rage drink about. Don't you worry about it.
So here is my big problem with Bev trying to run through these general instructions. I joke about I don't know why they made me 4-person. They made me 4-person because I understood all the legalese that we were taking back there, and I was the only one that took 37 pages of notes. Again, kids, don't be the teacher's favorite. You'll get called on in math class. That being said, all of this is like Cantonese to people that don't understand it. And even the kind of easy instructions, people don't understand how incredibly important and or is in legal, phraseology. They don't understand, if this and this, then you have to mark this. It's very confusing. It's utterly kind of confounding. And I get that she wants to, breeze through this, but I worry that
I have to wholeheartedly disagree. All of this general stuff is waste of time. What you need to know is what is reasonable doubt. What you need to know is what are the charges and how do you define manslaughter? How do you define second-degree murder? And how do you define what's the last one? Leaving the scene of an accident. All of this. Don't believe someone because he's a cop. They don't get more trustworthy or less trustworthy. What you have to believe is what you know that you have heard because you are the arbiter of the truth, blah, 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 blah. There's so much wasted air spent in American cases because there's way too many lawyers huddling around. The only instructions you need is these 3 charges is brought against Karen Reed. 2, find her guilty of second-degree manslaughter. You will have to agree she has had premeditation and she hit him with a car. OVI manslaughter, you have to agree she was moving the car in a reckless way and by her actions unalive John O'Keefe, which you can read by this. All this shit they're talking about, hey, the sky is blue if it's not dark, because sometimes it's gray. It's waste of time.
I revised my opinion. I agree with you. Explain the charges better, because I will say I had to go back and explain those to them and all of that, even though we were given, this is what this means, this is what that means. I had to break it down. So, and it's not because the jurors around me weren't smart and intelligent and capable in, their respective fields. I'm just the nerd that watches this stuff like it's a sport because I don't understand sports.
Yeah, and the problem is the jury will lose interest before you get to the important part. The important part is, how do you satisfy the charges? All this stuff about we have been through 25 weeks of trial, and you have to remember that no such bias and bias can buy, and there's a lot of wasted time, and all of that is because at some point someone had a successful appeal. So we have to get a disclaimer in there. We have to get a disclaimer in for that. What we do is, and again, it's a different system. We go into the deliberation room. We don't do the closing arguments like here and do the jury instructions because the judge is in the room with us. The judge will read first charge. Did she intentionally hit John O'Keefe on or about January 29th around 12:30 to 38? And then we sit and say, well, I don't think they proved that. And the other one can say, well, I think he was. And then we'll discuss it. And then we'll say, at some point, because I yell a lot, we'll say, well, we agree that he wasn't hit at 12:32. Okay, so charge 1 is gone. Charge 2, did she, under the influence of alcohol, use her motor vehicle in a reckless way, and by that causing the death of John O'Keefe? And I would say, well, we know from Ryan Nagel's, the lady in the back of the car, that she even used her blinkers. Valhalla doesn't use his blinker when he's sober. So,
how dare you?
Well, I've been in your car. So
I use my blinkers every time.
And I would say no. We know that she was competent enough to do a 3-point turn. She didn't sideswipe any mailboxes. She used her blinkers, which is not reckless driving. And there's no signs that she was swerving all over the road. Actually, she drove at a slow pace because it took her 10 minutes to do a 5-minute drive. So I don't think you can say that she caused his death because she was recklessly using her vehicle under the influence. And then you'll go to the third charge, and that would be automatically out because there's no impact.
Okay, you guys, this is totally off topic, but I just left because I was hearing these really weird kind of screeching noises, and I thought someone was hurt. No, my son is just, look, he may not join the choir ever, but he's like, I believe I can fly, and he's got the voice thing.
Getting a little R. Kelly on.
And
not that one.
And he's
not that.
And I was like, "Are you okay?" He's like, "I'm just singing, Mom." And I was like, "Okay, well, congratulate. Okay, good. You're doing very good. Just gonna go back to my room now."
Yeah, as long as it's not the recorder, you can do what you want.
It sounded kind of like it, so I was on a rampage. I was like,
do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will I'll cover all those topics.
A judge can't overrule us. Everyone has 1 vote each, so we can do split decisions. It will then be told to the to the court that we have a unanimous decision or we have a split decision. We all have 1 vote each, so I have not have it yet that we have had split decisions, but I've seen it in big cases like murder cases where we have split decisions. Normally, split decisions will get appealed.
What page you on? Okay.
One suggestion there was indicate Commonwealth has introduced photographs and evidence.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think that has introduced more graphic.
Yeah, so I would just say you've seen photographs.
get to a microphone because I'm sitting here, audio boost
Terrible.
2, boost 10, boost 2, boost 10.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right. So the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right. So I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle. All right. So I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence, evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for.
I'm sorry, it's because I have to try and boost the non-microphone users, so Bev will be a little hot sometimes, but that's the first time in her life she's been that.
And during the course of the trial. You may not draw any unfavorable
Without
inferences
white
solely
claws.
from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
We're joining in the request. I don't know if we included that in our instruction, but we're joining in the Commonwealth request for that.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact
Hank is
photos.
Did you
humane
add the
practice.
signal
We'll get back to
instruction?
consciousness of guilt in a minute.
It's
I'm also
encrypted,
going
you know.
to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
You're right, we're looking to Aruba. We don't believe that there was really any.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified.
Did she just say the minor's name? All
She just mentioned the minor's name.
Jesus Christ, Bev.
And so we don't know this because we weren't able to see this, but apparently the niece had mentioned the Aruba. Yeah.
Way to go, Bev.
No, she was hot and
Way
bothered
to
at
go.
that point. Very, very humid under her robes. They're
But
pretending she's an actual judge and not a prosecutor. Well, she's doing what she does now. Send it to
I don't
Kurt.
know.
Send what to Kurt? Aruba? We didn't know about the Aruba because it was given by the niece. And I'm not going to say her name because we don't mention minors if we can avoid it. But Bev didn't care about that one.
No, we couldn't see it, but she's going to just throw her name out there. No big deal.
Well, but
Dumbass.
the state
No,
didn't put
Danny
anything
T, it was
in
mentioned
about
during this
Aruba.
trial when the niece was testifying. Sorry, Mo.
Okay, but the niece testified, but there's no other ancillary evidence bringing anything about Aruba in.
No.
Why would they put an instruction, kind of highlighting? Again, could we leave the minor
prior bad
children
act
out of
instructions
it?
are normal. It's to say you can't use that she was a bitch a month ago to find her guilty now. That's a prior
I'm gonna
bad
need
act
that
instruction.
in all of my trials.
Yeah, but
Prior
that's a standard
bitchiness is not
instruction.
allowed to be brought in.
This is actually to to save or to protect Karen Reed, to say just because she was a C word a month ago, it doesn't mean she did this.
Yeah.
Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
Sexual what?
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to ask you.
Sexting
So,
with Higgins?
all right. I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt. Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
So the only,
1 second, let me just pull that up. Okay,
Your Commonwealth requested clearly not for any change of operation in the instructions that were given other than there are 3 pronged malice. Essentially, the Commonwealth is requesting that the jury be instructed merely on third pronged malice, because that's the only one that really applies to the facts.
okay.
The Commonwealth, you're the first 2 prongs are essentially trained in this situation and avoid confusion.
Do you have supportive case law for me to single this out? What do you say, Mr. Unetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to human breeds body non-intent. It was just the third prong. He stated that in his opening. I imagine that's what the likely argument in his closing. I don't have a position on this. I just don't know, and of course, going through this analysis in your head as well, whether it's permissible or not. I just raise that as an issue, but I don't have confidence.
No. I haven't said anything.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we're preferring the court.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will never do so. You're not be looking like that.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on
to bolster their claims.
what they need to focus on.
No, because both sides wants it. Both sides wants it.
Okay. All right.
That's why she's saying, I will try and see if I can find something so we don't have to go through all the prongs, just the third one. How would you size Lally up? Height, weight, or depth? I'll take care of the rest. I would size him up by the lack of hair. He's very aerodynamical.
I don't know. I don't see him wearing Mr. O'Keefe's clothes and standing next to a rear bumper, so I don't know how we're supposed to quantify things anymore.
No, no,
like
no blue paint.
No blue
yeah, Shizzy deceptively. He works those camera angles, so he doesn't look like he's 5'2".
It's impressive. That's
yeah.
Impressive.
Hey, like Tom Cruise, he just stands on a milk crate.
What are we arguing
Did you see
about?
his
Practice?
soles? They were this thick.
We are arguing about both of them once. They want less instructions given because it'll just muddy the water. And I actually like that. The murder 2 instruction, I think it was.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe I'll do that. But let me see if I can find something. If I can find something that says I don't have to give those first 2 prongs, I'll let you know before you begin.
Yeah, I like it. I like that they're actually trying to waste less time.
If I alter it, it means I remove those 2. That's all.
But no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So lesser included offenses. Did you want an OUI instruction? You were. Okay. All right. Right. I think that's it. Aside from Mr. Leslie's motion regarding the exhibit. Right. Is there anything else that we're missing?
Just a couple of other issues. One is with regard to the doctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. We recall that we had agreed essentially on redaction subject to the court's ruling,
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it. I'm going to give them now. Can I hand this to the court?
Sure. Thank you. All right, so
The only other issue, Your Honor, is we do have a.
hold on 1 second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I prefer not to have to deal with it.
I do not believe this one to be in problem.
Okay.
Just a couple other things before we get to Mr. Leslie.
Yep.
One is that we do have the Dr. Wolf PowerPoint that we introduced in evidence on.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so we
Okay.
can redact it. It's not on right.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Okay.
All right.
And I think I did mention that we had a proposed verdict slip for counsel to Your Honor, but I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth, can I hand
Okay.
it? Copy to the court?
Sure. Is it the same as last year's, but now with a?
Because it's the American court system. The American court system is overpopulated with lawyers, and everyone wants to argue in their way because they are right. And I yell about it at every trial, and I'm told, well, you just don't get it. It's the freest country in the world. Well, you have a lot of lawyers who talk too much. And as I said, you don't need to talk about how a perceived bias should not be a part of it because you already instructed them about bias once. And you're not going to change their bias by saying you can't have bias. You just tell them, these are the charges. Did they prove it? Come back. I'll give you a ham sandwich. Was the defense able to get the PowerPoint in from Dr. Renscher and the x-rays, etc.? I thought it was an issue yesterday, but might be wrong. I don't think they were allowed to let in the PowerPoint, but the x-rays was admitted as far as I understood it. But there was some talk, I'm not sure.
I think they just had to redact the opinions in the PowerPoint.
I always get the, it needs to cover all the possibilities answer when I ask the American lawyers why it's not simple words. Yeah, and that's the problem because there will always be another lawyer saying, well, technically this could also, so let's make the jury instructions a little bit longer. All you need to do is tell them these are the charges, these are the burden of proof minimums that you need to reach. Go out and find her guilty or innocent. Boom, yaga baka baka.
Okay. All right. Oh, I digested it, Mr. Leslie. Go ahead, I'll hear you. Yannetti, jeez, I'm sorry.
We had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser included and the number of elements that are different for each lesser included. And we were uncomfortable with there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict, the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the lessest, or the least, I can say, of the lesser included offenses is simple operating under the influence where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing.
I like
When
this.
the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict is the most appropriate one.
Mr. Lally?
Your Honor, as a court probably well aware, the Commonwealth not requesting any lesser included, and I certainly understand that the support of the defense requested that the court was given.
What?
Having said that, the verdict slip was used in this matter last year. Commonwealth submitted more sufficient adapted to the defense request. The only other thing I would bring to
Bro, take the dick out of your mouth, bro.
While the case was going on,
Get to a damn microphone.
in which he had similar issues with, I believe, use at least part of the verdict slip from the first trial, in this case, as sort of template for the lesser included and instructed and verdict slip they utilized in action. I don't have a copy of it on me, but I can certainly get a copy of it. But that may be somewhat helpful, of course.
Okay, was that on murder case?
It was not, but it had to do with felony murder of homicide.
Yeah, I'll take a look at it. Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Wells is an excellent judge. We think that this verdict slip it provides the most clarity for the jury. That's why we're
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed? All right, so Madam Clerk, you have a copy up there?
The proposed, I think it's the only copy.
Okay, that's what I was wondering. Okay,
Do you need an extra copy?
sure. Yes. Or, you know what, just mark it for
After-
identification, Margaret.
After
do
last
that.
year's fiasco
Please.
with the jury instructions, I would think that they had developed a streamlined way to deal with that by now. If you're the court, if you're the Commonwealth, right?
Yeah.
If you're on the Commonwealth or from the court, Bev, and you take away from last year's nonsense that everything's fine as far as the jury instructions, you're high. You're absolutely high.
Yeah.
Yeah, but it seemed like they were looking at another one as well.
And I will say, it seems like they are going remarkably fast. I don't know if Bev said you'll have until noon. Or,
No, this is actually how charging conferences works, because this is nitpicking small details. There will be Alessi will go up in 2 seconds and give some argument about something that'll take 20 minutes. This is details. It's move the comma, move the I. It doesn't matter. These are smaller details that it's clerical stuff. She will then go back, rewrite whatever she thinks about it, send it out. They will come back with their, yeah, we agree or we disagree. The important part for the defense is just that the effing verdict slip is 100% understandable. You just need to write you if you don't agree on any single charges. Don't check the box. Just check the ones you 100% believe is proven beyond a reasonable doubt. Yeah, that's the problem last year, was that could only find her guilty or innocent in all 3 charges or guilty in the lesser included. So, that's how we do it in Massachusetts. Is this sped up? No, we talk this fast normally.
Just for ID.
LL for ID.
But yeah, we have it at 1.5 or something like that, because we're way behind.
Mr. Lally.
I just one request circling back to the constitutional instructions. The Commonwealth is withdrawing the request for the instruction.
Okay.
However, would be seeking to make some argument of reference to the arguments from the jury related to specific areas which we need additional proof. So the 2 areas that are sort of within that, which would like to make some arguments from the jury regarding, is the defendant's taking of the license from one metal theft in to Paris residence indictment, and then certain statements made in reference from the various clips of the later statements.
Okay.
In particular, would be the one where essentially she said
that was the revised one after they complained about it last year, because they didn't catch it in the charging conference last year. They changed it later, and now he's going to say something about implying guilt by her taking the car to her parents' house. Is that what I got?
Yeah, it sounds like it. It sounds like they're going to say she fled to her parents' house in Dighton.
Yeah, they're going to say consciousness of guilt. But I think they had the same thing in the first trial. Don't quote me. That her moving the car to her parents, showed that she didn't want anyone at John's house seeing the broken tail light. And
I think.
Yeah,
you're
even
right.
though it was left outside when everyone passed it, she came over, no one noticed it, and then she left because that's the conscience of guilt. Because everyone was at the house when she finally got out of the Section 12. But hey, it's Lally. Talking to a lawyer means you're guilty.
also, Lally, your hand gestures.
All right.
As a former
Mr.
theater
Nettie, do you want to
kid,
weigh in?
Yes, to that, I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clues.
Yes, so I did want to ask you though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well? Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Ms. Stevens? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redaction.
that's great. Thank you. One less thing we'll have to do today. I know. All right, so let's make that, are we switching that new redacted version with an exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proper communications.
She just took her car and drove to her parents' house to be with her parents. So how that's an inference of guilt, you have to be working for the Commonwealth to find that.
well, at least she didn't let it in, but she.
Did Mo stop or did I stop?
I think Mo stopped.
Mo's having a stroke.
Pause game is on point, let me tell you.
When she comes back, we're just going to sit here.
Yo, we were having technical difficulties before the stream started. It was getting a little sketchy.
Yeah, and she left with the car because the brother became pissed. Yep.
Yeah, she was at John O'Keefe's house.
Yeah,
John
Beck-
O'Keefe's
Beck
entire
didn't
family
want
was
her
there. Right. It was an awkward situation. I'd have left too.
Yeah. Well, Mo checked out for today. Oh, Mo's back.
Yay!
Turned out my son was using too much bandwidth, so apparently he's
Damn
trying
Minecraft.
to render animation. No
Cool.
idea.
Yeah, Mo's guilty. She left for her parents' house.
Proctor
I was going to get a ham
communications.
sandwich.
Testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just,
Get to Alessi. I need to pee so we can get him to a
209, is everybody in agreement that it's exhibit 209?
Yes.
Okay.
Just the court copy or do they need?
I blame Jamie.
No, I wrote on it. I need the Commonwealth.
This is a clean copy.
So that will now be 209 in evidence. You know what? Can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
So what do you think? Yeah. Yeah, so we'll switch it back to ID and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted in NNN? Or is it, no, it can say that.
Okay.
But this is the-
Oh, it's just NNN. It's not,
Well, where did it?
no, it became 209.
So that has to
Our thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just.
209,
Yes.
yep.
There was a bunch of cocks she didn't want. Paul had his balls out, which is gross, so she just went to drive and see what was available at the rents. Potentially. Well, that's an inference of guilt if you like Richards.
And why would she be going over to her parents' house to find more Richards?
Well, maybe they have, John and Jill down the street who has that nice son who's a doctor. He just became single, and he has that BO problem, but he's really nice. And maybe they could have a smorgasbord and a charcuterie platter, and who knows, Mo? She was single, he was single. I know she was newly single, but again, you got to strike when the iron is hot.
Fair point.
Variety is the spice of life, Mo. Again, Mo have 6 kids. She knows about variety. She doesn't just do grits. She does flavored grits as well.
Look, I have a safety on my spice rack for a reason.
Yeah, she's actually, I think she's being fair today. They are getting what they should get.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Leslie, I'll hear you.
Thank you, Your Honor. If I might suggest, respectfully, a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and introduction into evidence of exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there. It may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in the final charge. What Commonwealth will submit is that the contemporaneous instruction is more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court final charge.
Okay. All right, I'll hear you, Mr. Leslie.
Let's do a walk-on music just to have a break.
The master of the mind game whispers your downfall, you don't even know his name. Silk tongue, steel trap, every word a blade. The sweet talk, you're writing to your grave. Call deadly, A-L-E-S-S-I. Just weapon pays the decree. Sweet word, sharp turn, now you're down on the floor. Brain buster hits and you ain't getting up no more. Call deadly, A-L-E-S-S-I. Logic's his weapon, pain's the decree. Sweet word, sharp turn, now you're down on the floor. Brain buster hits and you ain't getting up no more. He don't yell, he persuades. He don't fight, he invades. Step in the ring and you'll understand. This ain't brawn, this is chess, play my hand. Call deadly, A-L-E-S-S-I. I'm logic like TNT. He'll outthink, out of, and make you regret. One brain buster later and you're losing that bet.
We don't know why Hank is nagging. I think because I don't think he's a procedures kind of guy. I think he's a, I'm going to make you cry or I'm going to cry kind of guy. Most of it is when he's pantsless, he's crying a lot. I've heard. I have no confirmation of that. I don't know anything about his. I think the official term is a micropene, but I'm not sure. I've never done well, I did do some leg drops on friends back in the day.
I mean, who hasn't?
Yeah. Well, now I'll turn on Alessi. He'll talk, and I will pee.
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it is Exhibit A and Exhibit B. And those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly. But I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt to the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A. And it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan. And Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest, given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023.
Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue.
Start the fire.
So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point.
Ooh.
The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you.
Val, you ever do something that really singed someone's ball sack? No, I don't think so. However, I was on a tour bus of a band that you've heard of. And there was a can of hairspray and a lighter and a maneuver that he referred to as the hiding turtle. Take that for what it is.
And let's go. Thank you. Has to mention Hank got donged with a Roman war helmet, and at least he's keeping it kosher. His mom will be proud.
I do just want to point out one thing. It was not objected to.
That's why he was
at the
so
time
mad
it
about
came
the
in.
ham sandwich.
That's my only
Yes, it
comment. I will
was.
consider this. I'm going to hear from Mr.
That
Lally.
was
I
the
will consider
rage.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just thank you for raising that. 10 seconds for that. I will and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney
Definition of ambush.
retrieved it and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally?
Agreed.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth power conduct of counsel. During the heat of trial, during the heat of the extended exchange with the witness on stand, things can happen. Mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of.
No, it wasn't.
No, it wasn't.
No.
Bev basically said, oopsie daisy, these things
Yeah, it
happen.
happens. And
Not-
Brennan said, I didn't know that. Well, Lally, you fucking pillock. You sorry excuse for a man. You should have said, oh. Sorry. No, Brennan, you got that wrong. But what did you do? I'm going to play with my little clips because I'm demoted. I have to sit next to the man who stole my money. And I like that Brennan evolved a ball spot just to feel at home with Lally.
Yeah, it was.
He still has that
present
really
in
distinct
this
stripe
fight.
where the Just for Men can was too close.
Is it hair dye or is it like a daily spray on?
Well, I'm going with it's
Isn't
a
it-
daily spray on because it's funnier.
I remember them back in the day when you saw the commercial for
Yeah.
them. Isn't it like a foam they put in so it kind of looks like you have hair?
When
We
you
have
start
a
Yeah,
sweating, it starts dripping down your
fiber
face.
spray.
Yeah.
we have a pizzeria in down in the party street of my town, and the guy who owns it, he has the worst hair plugs, and he doesn't admit he has them. It's the ones where you can see the rows because he again, most pizzerias are owned by Turkish people in Denmark, and he went to Turkey to get the hair plugs, and he just had rows in perfect lines.
Looks like one of those cheap Chinese dolls that you get at
forget
the
the
dollar
hair
store.
plugs. How did the boob jobs look from Turkey? I mean, if I want to save a buck.
You know, for
Well,
research purposes, we should look into that.
We
I
should look
think
into that.
most of them are pretty good. You might get sepsis. You might get all the buildup of. I've seen one. We had a show about
Never
a
mind,
girl
I'll
who
stick
has
with
really
Mexico.
big chitlets at some point, and she got some kind of calcifying around it. So she had a doctor crack them. So I would spend the extra $500.
Well,
Nah,
yeah, I
don't
just want
go,
mine
don't go to Turkey to
reduced.
save those $500. You'll pay in the long run.
Yeah, I would. Oh, Turkey
Well,
is
we're
for
not
teeth
talking
and
over
hair.
court because we are talking when court is over, when it's court. So we try not to talk over court.
I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessio.
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. Ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things
start
take a little while.
at
Generally, that will
9:15.
assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask the counsel plan on just a half an hour lunch break. I'd like the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least hopefully there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, judges, during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Security issues.
Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right, so we'll see counsel
send a
in
cop
here no
with to
later than
make
8:30 tomorrow morning. We'll counsel here at 8:30. All right, thank you.
All right, court, please.
I hate those people.
Is there already one of these, like, are we swapping?
Yes.
Goodbye.
No, we're not sequestering the jury. It's just security. I don't know
What's she
security
talking
she
about?
needs.
Sending a bailiff with Yannetti and them to make sure Karen doesn't take off? Is that what she's talking about?
No, it's
maybe-
that they can't go too far away because they have all the demonstrations out there. I think is what she was implying. But again, I don't understand her. She is kind of weird.
Hey, thank you so much.
Shut up. But
That guy's hair bothers the crap out of me. His hair is way too high. It's like
He's too plastic. He reminds me of a Ken doll. I kind of want to, just see if he actually has a belly button, which is a weird thing. But there's something uncanny valley about him.
yeah, something. It might be a crash restriction. What evidence, Ken? What evidence are you talking about?
well, you don't need to crash reconstruct, which is all the evidence to prove John was hit, because all the evidence that you wouldn't get is what proves he was hit. But
The only thing that I could argue as evidence is the taillight pieces, right? And aside from
Yeah.
all the problematic details involved with the mapping of these pieces and where they were in relation to supposed crash and alleged body deposit, etc., I
But-
truthfully believe that was planted evidence, without
Yeah.
a doubt in my mind. They planted that shit.
but you all
And the
know
stupid. I was going to say the
I
stupid
just-
T-shirt of the day is if you're salty, at least bring the tequila. And I know we're talking over each other. We're all just hanging on here.
it's 32 days in. We are all sick. We are hanging on. But someone who is also sick but is hanging on, my good close friend Plevin, who is I think fighting terminal cancer for the 4th or maybe 5th time. He's always one to raise the bar because
Just so we're clear, fuck cancer.
fuck
Yes,
cancer,
yes,
and I
we
don't
don't
wish
like
it on
cancer.
my worst enemy or Plevin. But he is always a beacon of the highest integrity. He is a man who I always go to because I can get a little salty. I use the C word a lot, and I'm not talking about cocky. So I go to Plevin to be better. And Plevin has this message that I think we should all listen to.
So if you're a family member of David Yannetti, you live around here, right? We know he has kids. I'm sorry, your dad is a liar. Your dad sitting down with us in recorded interviews, lied. Just lied. So if you're a family member of David Yannetti, you live around here, right?
Bro, your
highest level of integrity. But
again, I would like to point out the side of righteousness is now bringing someone else's kids into things. I would like to point out the side that has all the morals and outrage and, you guys are stupid is now, again, targeting someone's family members like they did Dr. Wolf, like I'm sure they're doing to Dr. Rentschler, and, putting 1-star reviews on Dr. La Posada's independent consulting firm. So, again, tell me who's got the moral high ground, because I'm about done and I don't have enough Dimetapp or Dayquil to deal with stupid.
Well, I can, again, this is, I wouldn't even call it a 2-cent pony show, what we have been doing. We are the worst of the worst, the lowest of the lowest. So I go to other channels to see how the trial really, because we don't understand. We don't get all the nuances.
No, how could
Someone might have had a bad day yesterday. I'm going to play 2 clips for you. They're a little bit longer, but you will enjoy because it's smart people for once talking.
Oh, thank God.
Rebuttal tomorrow morning, and I think it'll probably be done tomorrow morning, right? Who's coming on rebuttal, Kate? Just Dr. Rentschler? I mean, Dr. Rentschler.
It might just be just Dr. Rentschler, maybe dog DNA.
I mean, not Rentschler. I mean,
well,
Yeah. Oh my God, we did the same thing.
Oh,
that
no.
Jackson was
I'm doing the same thing.
Yeah.
Now it's the Alan Jackson effect.
Kevin, it's Terry Kuhn, the dog DNA, and Maureen Harnett of the crime lab is also going to test.
Right. And she's the one that swabbed the DNA. She swabbed it, not Michael Proctor.
Yeah, that's right.
I don't know if I would call him. Honestly, I don't know if I would call them if I were him. I know that he said that.
No, that's Kate Peters, Crusty Pandies.
Oh, the profile that makes you beg for blindness.
Well,
And
I'm
a
not saying
voice
that her
for
mom
silent
was
movies.
raped by Sasquatch, but she looks kind of like Sasquatch.
That he intended to, and he may, but I don't think that I would at this point because it's so weak. He's already introduced that there's no dog DNA, so he can use that in closing, and it's already been introduced to the jury anyway. And I don't know if I'd want to open up the jury to the bullshit. They're going to cross Maureen Hartman on the holes in the sweatshirt a bunch, and it just seems redundant for something that it doesn't make any sense. And they've heard more experts than not refer to them as superficial abrasions, including Rentschler over and over again just now. So I think that, I don't know. I don't know that I would do it. We'll see what he does.
Well, I think Hank has a way of doing things very efficiently, so I think it'll be a relatively quick examination just to get it on the record. Because you've had now a couple witnesses implying, or at least both one testifying and one sneaking in testimony that these were from an animal. So I think it's important to get that up there with the DNA stuff.
And also, during defense, we haven't seen, he hasn't been able to play the Karen clips. So if there's some way that by playing one of her own clips could rebut something that came in with the defense, then to me,
Just to entertain you a little bit, and I like that their biggest comeback is play some more clips because we don't have evidence.
More out of context statements.
Wallstrom, I said I'm going to play 2 clips for you. Just listen how Hank is going to swing everything on rebuttal.
you look for any opportunity to play her.
Oh, yeah.
Because
the clips
right.
rule.
Yeah. And you guys also, I think there's a false, and we can all tell, there's a false sense with the supporters that because, the defense is up, that they're like, here we go, and they're turning the tide. But I think it's a false sense of strength that they're feeling right now. Because we know Hank's going to get rebuttal.
Your
and
wonder
then
bra is false.
Let's just listen to that again. We have a wrong sense of strength because
his closing is going to be strong. So, and then his closing is going to be strong.
Go back.
Right now. I think it's a false sense of strength that they're feeling right now. Because we know Hank's going to get rebuttal, and then his closing is going to be strong. So I think he's in a really good position.
Good Lord.
So that was before the break yesterday.
There's our final curveball. No rebuttal.
And let's see what they said when court ended yesterday. And I have to say, I believe I talked to Larry Legend about this before, that I could use his clips. But if not, go to X and follow Larry Legend.
There's our final curveball. No rebuttal.
Goodbye.
Mm-hmm. I think honestly, it leaves Hank looking strong, like he's got nothing left to prove.
Is that what you call what do you call it? Dissonance, cognitive dissonance.
Oh,
hey, the other side think that they're strong, but Hank is going to fix that because he's going to go up there. I actually think it makes Hank look strong because he's not going to go up there.
Cope harder. Cope harder.
I'm just saying Lefty makes better arguments than this one.
Like, I understand that, the rebuttal could be, useful, but this is just like, to me, in my opinion, it's a strong ending. He's got nothing left to prove. He doesn't want to burn the jury out any more than they already are. Might be a safe bet.
You're an idiot.
Play devil's advocate. Could it be because they don't want the X-ray conversation to happen with Welcher?
Holy crap! A smart one.
Possible. It's possible. But either
So
way, I
we're
think
giving the defense the last word, and their last two witnesses were pretty solid witnesses.
I agree. It was a strong ending.
I don't know. I wouldn't say they were
their
both
side.
solid. I would say that out of the two, Lapalato was probably more convincing than the display we got out of Rentschler. By the end, Rentschler looked very questionable.
Oh, John DePetro. Retard level.
I mean, there were some
up.
chinks in the armor, but both of them were definitely
Why are you
qualified.
doing this?
Did he say
And
chinks? You
both of
can't
them
say
were
that on
used to
YouTube.
testifying, so they knew how to testify, and they scored their points. Is that enough to create reasonable doubt?
Kevin, two things. One, Kate was right. Kate predicted, maybe said no rebuttal. But if there is someone on that jury that either through their own belief or that just Alan Jackson played to him or her, I agree with you, Kevin, that if you're of that mindset, what they did do was maybe give you some ammunition to hold out on a guilty.
You're such a fraud, John DePetro. Who said China House? No one said China House. They said Asian House. That was Matt McCabe who said Asian House.
The Asian House.
Yeah, absolutely.
Yeah.
So, I wouldn't want to be a betting man on this case right now, to be honest with you.
Mm.
I don't think there's any chance at acquittal, but
No.
I guess if I had to bet my life, I would choose on a hung jury again.
Really?
Yeah, I don't think
Even on
the
the
state's case.
manslaughter?
Let me just say, Plevin wrote a book where he talked about the strong 100% accurate evidence that would come in with the chip off that would save the case, because they would even have the exact time he unbuckled his seatbelt. And now Plevin, who is, I actually think he's intelligent, because he saw it's better to be a big, stupid fish in a small pond than be over here in the big pond with the rest of us when you have to grift people for money. Hey, thank you, Lefty. I make better arguments, and I've spent less time watching this than Yellow Cottage Cheese and Doink have spent inside a woman. Well, both of them spent 9 months inside a woman. But other than that, well, there are some rumors about what happened at Plevin's bar, but don't look too much into that. But I think that early on, Plevin saw, hey, there's no one else who can kind of string a sentence together on the other side. So let me go over there and grift the short bus for money. Then he found out the short bus is run mostly on EBT cards. So not that good of a grift. But now he's sitting here saying, I don't think she's going to get convicted. This asshole have been selling anything he could to try and get her convicted. He has been working with the Commonwealth.
What do you think he's doing there? You think he's trying to save face, or is he
Again, just being
not
a
confident
casual
in the case?
He has to see the trends. He has to see that Hank was trending yesterday, that all the ham sandwiches, again, if he hasn't blocked off everyone from the free Karen Reed, section, he has to realize that this is utterly damning, that even on law and crime, who generally think all defendants are guilty because the state brought something in, it is skewing heavily to not guilty, which is really something that we've rarely seen in any trial. I mean, again, comparatively, I think 9 times out of 10, my chat when we vote are in vast disagreement with law and crime. So I think he's hedging his bets.
Yeah, and Brandon, you might be right that some of them. Oh, most dying. You might be right that some of these make bank. They get a lot of more views than I do. So at least they're making those big advertising dollars, which is around what I get is $5 for 1,000 views. So you can make up to maybe $15 in advertising. But I still think they would get demonetized every time because Plevin is on screen, and the AI will pick it up and say someone is showing a peen. But
he does kind of look like a peen.
Yeah.
Well,
did you miss another spicy moment? No, I kept my pants on today. So
far.
I thought I hit the mute. I hit the camera and then coughed because I've been trying to be good about that.
Did the state DA, Michael Morrissey, that's the same, tell Brennan to not speak at all today? Why was he absolute silent and let Lally argue his F-ups? I think it's because Lally is a prosecutor. He knows how to talk to the judge. Brennan is a talker. He's not a details guy. I think that's why, because Lally knows what the rules are.
I think he was also working on his closing. I think that's, he was probably getting like all the clips he could and, making them into a thing. I'm sure he's going to have that's my question. Is he going to sprinkle in the clips, or is he just going to he's going to finish talking?
He's going to have a 1 hour and 15-minute montage, and then, 1 hour and 14-minute montage, and then he's going to yell, I hit him, I hit him, I hit him, for 1 minute, and that's his closing.
It sparks with truth.
Plevin can't be wrong. He's a narcissist. Well, Plevin sang a quite different song with 5 minutes between them. Let's hear more.
I just don't know if the state's case was convincing enough to get 12 jurors. And the combination of the jury pool contamination that took place for the last couple of years, that was very effective. And some of the witnesses for the defense were somewhat effective. And the state didn't give a perfect case. They did much better this time around, but they still didn't have a very clear explanation for things like John's injuries. So, I mean, they offered a lot of other evidence, but this was weeks ago. Will it all be remembered? I don't know. To get 12 is going to be tough.
Well, I think Hank, strong close. And remember, to me, the ace in the hole are the Karen clips. So her own words about
out of court statements, out of context.
How could I have clipped him if it's dog bites and someone planted stuff? I mean, again, we'll know.
John DePeltro, blame your wife for your idiocracy, being stupid. Someone planting stuff is less strong than Karen Reed saying Peck didn't want me there in a clip taken out of context. You pretend to be a journalist. How can these people even breathe and chew gum at the same time? They're so stupid.
Well, they have no concept of law. They have no concept of individual rights. They're just based on emotions and the grift, I think.
Yeah. Yeah, Stephen, I've seen it said a lot, but he's never replied to it. But I haven't seen, the only things I've seen online about his criminal record is, well, I can't remember. The girls found it for me one time. There was nothing, some unpaid taxes or something. But they sold the bar really cheap, and now it's a really hot spot. Revenues have dropped significantly post Marissa's firing. You need to apologize to her or hire Terry Tate. Who's Terry Tate? To improve moral. Marissa hasn't been fired. She has been moved inside of the structure of Baker Media. She is now going to do, every night, she's going to do a night show from 11 to 1 Eastern Standard, where she will run down all the most important parts on Twit every day. It's going to be on the X. She will be on X while doing this show. It is probably going to get demonetized most nights. And I can only say this because Marissa is not online today. She is chaperoning. So I can say all of this. Tomorrow, she will make me pay by most likely Nancy Kerrigan, my niece.
Yes.
So,
After
Terry-
chaperoning, a bunch of kiddos around an aquarium, she might be ready for vengeance.
Oh.
That's not good.
Well,
Terry Tate, for the record, is a fictional linebacker that was in a bunch of commercials, and he would tackle people.
Oh, that's the office linebacker, the one that hits
yeah.
everyone.
Yeah,
I thought it was. What is the name of the one who banged Burt Reynolds? Wasn't that Terry Taylor?
No idea.
Burt Reynolds got.
Yeah, he got banged a lot.
What?
He was in Playgirl.
Well,
Yeah, he was.
Yeah, but by a linebacker?
No,
Right?
I'm saying
No.
I thought
No.
Terry Taylor was the one who banged.
Betty White.
I'm just like, wait, where are we going with Burt Reynolds, and why is he getting, a nice time with a linebacker, which I don't care about in the month of June, but Terry Garr was
Terry
pretty
Garr.
hot back in the day.
Maybe.
She was the actress on Mr. Mom, the movie. She was the wife.
I never seen that movie.
That's
Oh
with Billy
my
Crystal.
Bob Ross.
They don't take taxes off the top of the super chats. Depends on where you're taxed. I have to pay taxes, business tax on mine, but I don't have to pay sales tax because they have already taken them off.
I think
in America they tax it differently.
I think they tax it before they pay you out. I think it gets deducted automatically before we ever see it.
Yeah, I don't know if they do that, and I can't really figure it out. I have an accountant. Hopefully he can figure it out.
Same. I don't know.
Same.
I don't trust myself to deal with that nonsense. I'm not going to
Third
federal
was with
prison 'cause
Lonnie
I can't
Anderson.
math.
Yeah, she was hot.
Lonnie Anderson was
Listen,
hot.
y'all have seen how I react in the face of math.
Young Frank. What's her name?
Keaton, not
Terry
whoever
Garr?
you said Valhalla. Diane Keaton?
What? Keaton, not whoever.
I like that
Oh,
ex-wife.
it was Michael Keaton,
movie.
not Billy Crystal. You're right. I get those two confused all the time. All the time.
But I like that ex-wife club with her and Bette Midler and
The First Wives Club, yeah.
First Wife Club. Yeah. You don't know me. Na 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 na.
After closing, unless Alan Jackson pulls something really out, or Hank somehow, which I don't think he will, bungled it. But Kevin, we're going to disagree. I think Hank has gotten the guilty on the murder too.
I hope
I
so.
do.
I hope you're right,
Yeah.
man. I hope you're right.
Yeah.
On the murder too. You think you got the murder? You got the whole.
I
You got the
do.
whole thing then.
Yeah,
I do.
I'm kind of in between you guys, your opinions. I think that
I wish I could enhance this photo. This is self-awareness.
Is that
But
Karen
who
Reed
is
in the Hannibal
Boomer?
Lecter getup?
Yes, but it's more that Kate Peters has that avatar because she should be in a mask, so we couldn't see her face.
the manslaughter is going to be the slam dunk, but I lean towards Murder 2 is more than on the table, though. I don't know if I'm as confident as you are, Sean, with Murder 2, but I don't negate it, though. I think.
And I don't know who Boomer is.
For me, as a guy that didn't watch the first trial, I felt that the prosecution of the Commonwealth did their job in this case.
This background is worse than, sorry, Larry, DUI guys and legal eagles combined.
With
It's very
the
busy.
legal library back there?
Yeah, they have the legal library and the black oak or dark oak shelving, so it really looks professional. This guy,
believe it's mahogany.
hey, I'm solving crimes over here. Get out of here. Nothing happens in Boston without me finding out.
Baker,
Look,
it's a
I
green
got all them
screen.
here maps. Sorry.
I think that she will. My biggest concern is jury tampering. Is there a juror that is free Karen Reed? If they actually got a unbiased jury,
I'd have no worries whatsoever about the ruling in this case. In the end, though, I think that it's going to depend on how Hank articulates murder too. If he can get it across and through to the jury that in that state that intent isn't the main focal point for this reason being it's for this being murder too, and it's just basically the act, and that a reasonable.
No, you need intent for it to be murder too. It's manslaughter if it's just the act.
He's stupid. He's stupid.
Am I wrong? Am I wrong?
No,
you need intent for murder.
Yes, there has to be, because if you were just reckless, what takes it from reckless, a manslaughter, to murder is,
intent.
2 is in the heat of the moment, but you still made the decision to do it, and then murder 1 is, minus the heat of the moment, you still made the intentional move and did it.
Yeah, you did this on purpose.
Yeah. Now,
without
murder
intent,
2 is like
you just what the hell? That's murder. That's manslaughter.
Yeah, murder 2 is like we were fighting, and she reached over, tried to slap her purse back because she was fighting so much with him. Saw him in the background and thought, just whatever. I'm going to speed backwards and. Okay, guys. How much more of this do we have to listen to, Baker?
Only 9 more seconds. Wife is so sensitive. Okay. She got a haircut just 2 inches off, came home and cried for 2 hours. Finally, I said, why are you upset? It's just a haircut. I'm the one who has to find a new wife.
Lesko, I finally agree with you. I am never cutting my hair, and I made my husband a promise I would never get a short haircut. It is a contractual thing in our relationship. Grounds for divorce.
That's fair.
Yeah, Pixie cut takes a lot of special facial features to carry that. Most women can't pull a short haircut off. I'm sorry. Most men can't pull off long hair. Well, you can pull the long hair if you know what I mean.
Person would believe that her traveling at over 70% throttle in reverse while intoxicated in those weather conditions, that a reasonable person would believe that could cause death. If he can get that through to the jury, I think they got her on murder.
It's not second degree.
I want to say too, watching chat, it's like deja vu. Man, you can go back to watch the first trial. Go back and look to the chat because I did this.
He had 13,000 views.
Unbelievable.
Guys, I'm not asking much, and I take ads off. I don't do all the YouTube things and, hey, everyone, please like and subscribe. But tell your neighbor about us. We are a fun bunch, and we are more intelligent than Plevin. I'll have to be fair and say Naval Lind is more intelligent than Plevin as well. So, but still, how can that a-hole beat us? That's not okay. What is the actual charge? Second degree red rum, OVI manslaughter, and leaving the scene of a crime. No, leaving a scene of an incident, deadly incident, something like that. So I also look, whatever throttle percentage she had, was the pedal all the way down without going through the kick point. I don't know, because we never talked about that 73. It's just like, 73% throttle. What is 73% throttle? Whenever you sit in your car, do you, I'm drunk, so I won't go over 22. That's 22%. Now it can't be reckless manslaughter. Levin didn't come to Dollywood. I invited him, and he said, I want you for myself. Yeah, the OVI is what they're going for. That he knows he doesn't have second degree.
I'm actually kind of surprised they're still charging her with it.
Yeah. Well, catching up, I think Bev's security comment was more about not guilty verdict and what this might mean. I don't think so, because the only people who has been outside are the pro Karen Reed people. Tires would be spinning. She wouldn't hit 24 miles per hour. Again, it's axle speed. It's not road speed. So we don't even know if she hit 24 miles per hour. That's the thing, because they don't have GPS data that can conclude that. They have momentum and blah, 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 but they couldn't tell us anything about how, when, or where that car did what it did. And to me, that alone should remove the second-degree red rum, because you can't prove intent if you can't prove she hit him willfully. You can say, well, she was drunk and she got into reverse and then she got into forward and accidentally hit John at that time. But none of the injuries lines up with it. She should never have been charged. Let's just say we are 3 years in. She should never have been charged.
Not even close.
You would think that a bunch of cops, because let's do this. John was in the basement. Higgins decided, they were going to play fight. Then it got a little bit more serious. Chloe decided, hey, someone's attacking. I'm going to get in there. Chloe bites him. He gets startled. He goes backward, hits the weight bench or something with a ridge on it in the basement. Why the hell didn't they make this look like a GD slip and fall on the front step? Then you have everyone vouch, it was slickery outside. Yeah, I kind of, I put out salt, but I didn't realize it was, Snowmageddon coming.
Oh.
You're telling me that that Proctor is going to investigate just as hard, a slip and fall? This has never made sense to me why they put him again.
Because Karen wasn't supposed to find him. That's the entire reasoning. Karen wasn't supposed to find him.
Later.
This is from our legal aid. Charged second-degree murder. Elements. Commonwealth must prove Karen did unalive John. She intended to, 1, unalive him, cause grievous bodily harm, do an act which, in the circumstances known to Karen, a reasonable person would have known, create a plain and strong likelihood that the death would be the result. C is what they wanted to testify and then take out A and B. Charge. Involuntary manslaughter, wanton reckless conduct. Karen caused John's death. Karen intended the conduct that caused John's death. Karen's conduct was wanton reckless. Karen operated a motor vehicle on a public way while under the influence of above 0.08. Charge leaving the scene of personal injury and death. Karen operated a motor vehicle. She operated it on a way in a place public has access in public road, i.e. public road. Karen knowingly collided with, injured a person, John. After the collision, did not stop to give her name, address, or registration. Those are the elements that the Commonwealth need to prove, and I believe the Commonwealth has failed in proving Karen hit John O'Keefe with a car.
Yeah, and that's the thing. I came into this, thinking maybe Hank was going to be better because I'd watched maybe 75% with you guys of the last trial. But I came in thinking, okay, if you can prove it to me, I'm willing to listen.
Yeah.
But you can't tell me where. You can't tell me exactly when this happened. You don't, again, apart from a very difficult to see black blobby sort of picture, we only have everyone else's words as to the approximate, placement of John. It just, none of this you can prove, to a reasonable degree of scientific certainty, because if you don't know when in the backing she hit him, you don't know where or how do you have a case?
You have a grand jury that can indict a ham sandwich, and you have a judge that'll let you say whatever you want. That's sadly how this is a case. Someone asked, what's the charge for an OVI? Up to 25 years. So that's actually just as much as the murder too.
The jury isn't to know any of the length of sentencing that could be possible with any of these. So
yeah.
That's never going to be in their calculation, or never should be.
But tomorrow we will find out.
Yes.
I'm going to take off because I'm still sick, and I'll take the rest. Mo's sick. She'll need the rest. Valhalla, he's a sick puppy. He'll probably need the rest. Mo and Valhalla hopefully have the redirect set up. We will be here 8:45 tomorrow because court starts early, but we don't give you the 10-minute intro because we know Bev will not be there at 8:45 ready to go. So streams will be set up for 8:45 tomorrow. Don't look at this channel for the maybe leaked rehearsal of closing arguments by Mr. Brennan. They will not be out there, and it will be absolutely truthful if they show up. Please go show Mo and Val a little bit of love. I think they are mentioned in the description. Do all the things you hate us to say, and go get some sleep. Get ready for tomorrow. It's going to be nail-bitingly mind-numbing, boring to listen to Bev giving her jury instructions. Then it's going to be an hour and 15 minutes of closing from the defense, where we think, good point. And then it's going to be an hour and 14 minutes of clips of Karen Reed saying various things out of context, and 1 minute of Jen McCabe doing this.
Hey, Jen!
And you don't want to miss it. So be here tomorrow. Bring a friend, bring a koozie, bring a whoopee, bring a support beverage, bring a support animal, and set your dial tones to... What is he talking about?
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.
Just pin it on the girl, right?